it will have that you'll see. But the main focus obviously is on the residential listing agreement, which is the one that we use probably 95% of the time. So, as mentioned, today is Mastering Contracts, which we do every Monday from 10 to 11. We follow that up every Wednesday from 10 to 11 with Mastering Transactions and close out the week with Mastering Your Business on Fridays from 10 to 11. So we've got standing appointments Monday, Wednesday, and Friday from 10 to 11 with classes that are hopefully going to lay the foundation for not only a successful 26, but for the rest of your real estate careers. In addition to that, we supplement our 3-time-a-week training with a 90-day calendar, which we call our pathways. And on that calendar, Monday through Friday, we send you a new task. That task is much like our Mastering Your Business session on Fridays, is something that's going to hopefully lay the foundation to building your business and getting you on track, getting you the idea of building a calendar and spending your time on income generating activities. And with those tasks, we give you everything you'll need to complete it, whether it's a video, a link to a web page, a how-to, a step-by-step. Again, anything and everything you'll need to accomplish that task. And our hope is at the end of 90 days, you will have gotten yourself into such a routine, okay, that just on a daily, weekly, monthly basis, you are continuing to achieve these activities. We've already had 2 groups that have made their way all the way through that 90-day calendar. Luckily, we've got a follow-up plan for them with Jackie's 333 Club, which starts next Tuesday. So hopefully everybody's seen those flyers and have had the opportunity to sign up and get their commitment letters signed and sent back for that. So if this isn't something you're currently receiving and or you're interested in learning more about it, put your name and your email address into the chat and we will get you signed up today. We actually had a group that just started this morning. Typically we send out that email sometime between 6 and 7 every morning. And again, it's Monday through Friday for the next 90 days. So name and email address into the chat and we will get you set up with today's task and you'll be good to go for the next 90 days. Let's see, what else do we have? I think that's about it in terms of kind of our PSAs for every morning. Now let's jump into what we're talking about today, and that is the listing agreement. So give me a second, I'll share my screen. I will apologize to anybody who was on Friday, as we did have more technical difficulties, which we are trying like heck to sort out and make sure that we don't have happen going forward. And for anybody that has been through this session, listing agreement session, it's pretty much the same. We haven't had an update to the listing agreement as of yet. If there will be one, it will be coming in the middle part of June. So, but for right now, the listing agreements that we're going to be looking at are still the ones with the December of 2025 revision dates. So first thing we're going to look at is just some basic parameters of a listing agreement. We will put this slide deck into the chat. Again, if you were with us on previous sessions, we used to have a Word doc that we included. We basically just upgraded it, put all that information into a slide deck just to be a little more consistent, because that's what we do with most of our training. So all the information is still the same. It's just in a little bit of a different format. So before we actually get to the contract itself, and what we'll do is we'll just go through the basic outline and parameters of real estate contracts in California. Then what we'll do is we'll jump over to the actual contract and look at some of the different sections that we want people to understand, be mindful of, and know a little more about. Okay, so to have a valid listing agreement in California, okay, it has to have a number of sort of mandated or required things. So, which are, oh, well, let me back up, and sorry to jump around, but we're focusing, as we mentioned, on the residential listing agreement, the exclusive authorization and right to sell. Okay, that's the one we use 95% of the time. But just so everybody knows, there are actually 6 different listing packages in zip forms. Okay, we have the one that we're going to be talking about today, and the one that was most used, and that is the residential exclusive listing agreement. Okay, and this is what we refer to as the RLA. Okay, residential listing agreement. Then there is the residential open listing agreement. Okay, and an open listing agreement basically means the seller can sign an agreement with you, but they can also sign an agreement with another broker, 2 other brokers, 10 other brokers, 100 other brokers. Okay, and whoever brings them the offer that they accept is the one that's going to get paid. Okay, we don't recommend open listing agreements. You can do all the work, okay, and not get paid and have no right to get paid. Okay, the beauty behind the residential listing agreement or the exclusive authorization and right to sell, the one that we use, is that you do all the work, offers come in, seller accepts and sells, you know you're going to get paid. Okay, with an open listing agreement, you don't know if you're going to get paid or not. A seller has no obligation to actually work with you. Okay, then there's the residential seller reserved listing agreement, which basically means the seller is only working with you. Okay, it's not an open listing agreement. They're not going to have 10 other brokerages trying to sell the property. Okay, but the seller reserved means they reserve the right, okay, to sell it themselves. Meaning that, again, you can do all the work. If they go out and find the buyer, okay, you may not get paid. Okay, so with the residential open and the residential seller reserved, they're not listing agreements that we recommend our agents take part in. Okay, because you're going to work too hard, you're going to spend too much time, effort, energy, and a lot of times money on these listings, okay, not to have a guarantee of getting paid. Now, obviously, with the residential listing agreement, the exclusive, there is no guarantee that the property will sell, okay, but at least you have the comfort of knowing that you're the only one who can sell this property. Okay, you're not going to be competing against the seller who's trying to find a buyer and or competing against other brokerages who are trying to find buyers. All right. Now, in addition to the 3 different residential listing agreements, there's 3 others. Okay, there's a commercial residential income. All right, so anything 5 units and above or commercial would be commercial residential income. You have your vacant land listing agreement and your business listing agreement. Now, we do have basic parameters in place for commercial listings or sales, vacant land listings or sales, business listings or sales. Okay, so if you're new to the business and haven't had any experience with any of those, okay, then you need to reach out to myself, Jim Kelsey, our commercial director, your regional advisor, regional director, okay, and we'll give you kind of the breakdown of the parameters, okay, of what it entails to go through with one of those listings, okay? And in most cases, it's going to be partnering you up with somebody who has more experience, okay, especially on the first one, okay? So as we mentioned, for this training, we're actually going to be just focusing on our exclusive package, all right? But just want to make sure everybody's familiar with the different listing agreements that we have. So in the residential listing package, okay, and we keep saying package, 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 and all these things. And that's because when you go into zip forms, okay, and you type in RLA or you type in residential listing agreement or just even listing agreement, it's going to pull up all the different matches to that search. So if you just type in listing agreement, it's going to pull up 6 of them. But in each of those agreements, okay, is a whole package. Okay, and they all include ancillary documents that you're going to need, okay, to actually list a property. So in the exclusive or the RLA package, okay, there's actually 21 pages total. All right, and it's going to include your agency disclosure. All right, when we talk about disclosures and other documents, okay, you're going to hear me say, and if you've been on that, agency disclosure is the most important document in any real estate transaction. Okay, that is your do not go, do not collect 200, or do not pass go, do not collect $200. Without signing that, okay, you can't have any other documents signed and be valid. Okay, that document has to be signed first. And that's why you'll notice when we look at these packages, that's always going to be the first document. okay, whether it's a listing, purchase, lease, anything, okay? The agency relationship is always the first document, needs to be signed first. Okay, so that's 2 pages. Then you actually have your listing agreement, okay, sets forth the parameters of the actual listing, and that's 7 pages. You have your multiple listing service addendum, okay, advising the sellers on why it's important to use a multiple listing service. That's 3 pages. You have your broker compensation advisory, which is 2 pages, outlines how the new compensation rules work. And we say new, they're not new anymore, but they're new to the structure of the business in that it's only been around for a few years the way things work now. Okay, possible representation of more than one buyer or seller. Okay, it's 2 pages, letting the seller know that, hey, we may have other listings, okay, and we may represent buyers, and we may even represent buyers for this particular property. Okay, and they need to understand and agree to that. Okay, and if they don't, then it's up to us to determine if we actually want to work with them or not. Fair housing and discrimination advisory, 2 pages. Seller advisory, 2 pages. And then the Consumer Privacy Act, 1 page. Okay, so all told, 21 pages. And again, if we just click on listing agreement, it's going to pull in that whole package through zip forms. Okay, so now when talking about the listing agreement, okay, there's some basic contract requirements. All right, so, and this is, elements of most contracts, not exclusive to the listing agreement. In order to have a valid contract between parties, you have to have competent parties, okay, meaning that the seller has a legal capacity and authority to sign this contract. All right. You have to have an offer and acceptance, all right, meaning a clear agreement between the parties that the seller is employing us to sell that property, and we, for consideration, which is the next requirement, okay, that consideration is compensation, that we agree, okay, to their offer. Okay, then it also has to have a legal purpose, meaning the listing cannot require unlawful conduct. Okay, and then one of the most important things for contracts in California is it has to be written, okay, and signed. Now, does it have to be actually on a CAR form? Absolutely not. Okay, as long as the contract has all of the required elements, okay, it can be written in any form as long as it's written and signed. Okay, Word document, typed up, signed, valid. CAR contract, fill in the blanks, signed, valid. Okay, at a restaurant or a bar, and it's written on the back of a cocktail napkin. Okay, written and signed, valid contract. Okay, so just basic contract law in California. Now, for an actual listing agreement in California, okay, there are some additional requirements that everything must have to be valid. Okay, the first is you have to identify the property to be sold. Okay, street address is the most commonly used way to identify the property. Okay, but a legal description and or an APN number may be a more valid way of identifying a property. Okay, there's some properties out there that don't have street addresses yet. Okay, or the street address is ambiguous, whether it is like if it's a multi-unit, whether it's a unit 1 or unit A, or it has multiple addresses for a particular property. So a lot of times legal description and or APN number, assessor parcel number, is a better way to describe the property. Okay, it has to have the terms of the sale. Okay, the pricing, the timing, financing, anything included or excluded. Okay, and any seller-specific requirements. Okay, that they are going to want in that contract. All right, has to establish the broker's authority. Okay, now one thing to remember is listings are with a brokerage. Okay, purchase contracts are with a brokerage. Okay, it doesn't say agent's authority, it's broker. Okay, so everything belongs to the broker. The agents are just acting on behalf of the broker. Okay, so establishing the broker's authority, meaning how can we market it? Is it going to go into MLS? How are we allowed to cooperate with other entities? Okay, how are offers and deposits being handled? All right. There needs to be some type of compensation. Okay. The amount, the rate, the conditions that the brokerage is going to earn compensation for selling the property. All right. It has to specify a termination date. Now, the funny thing is, it says nothing about an actual start date. Okay. But it has to have a termination date. There's going to be additional restrictions to that that we'll see when we actually get to the contract. Okay. So it doesn't have to have a start date. Okay. But we do have to have an end date. And then it has to be in writing and obviously signed by the seller. Okay. So just a little more detail. We're talking about you have to identify the property and the terms of the sale. Legal description is ideal. APN is APN is okay. Street address is fine, and that's typically what we use on residential properties. Okay, but again, it may not be ideal given if there's some ambiguity to the actual street address. Okay, has to have the listing price. Okay, we need to document the cash price that the seller wants presented to the market. Now, this is a little important in terms of ensuring our commission. Okay, because a lot of times the price that we are putting on our listing agreement is a marketing price, not necessarily the price that the seller will accept. Okay, so it's important to make sure that you're having a conversation with the seller and denoting that. Okay, because technically, if we bring a ready, willing, and able buyer, okay, to the table under the terms of our listing agreement, the seller could be obligated to pay us a commission, regardless of if they accept the offer or close escrow. Okay, so that comes into play when there's ever a dispute and we're trying to fight for commission. All right, we need to also identify if there's any special terms. A closing date, if the seller wants to carry back some financing. Okay, if they are hoping or wanting the new buyer to assume any part of the loan, or more importantly, something like solar. Okay, assume the lien and or the rent payments on the solar. Okay, if the seller needs any type of rent back credit or anything else in order to be able to close escrow successfully. All right. And then they also need to identify what they're intending to include, okay, or exclude from the sale. All right. Anything, and we'll look at this in a little bit actually on the contract, but anything that's attached to the property is usually assumed that it's going to convey with the property. Okay. So if the seller is attached to the chandelier in the dining room, okay, it's a family heirloom, they need to identify that that's not going to be part of the sale. Okay, if there's cabinets in the garage that they took out of their grandfather's shed, that are 125 years old, and they're not going to stay in the garage at close of escrow, they need to identify that those are not included. Okay, or if the seller just won the lottery and is going to travel around the world on a cruise ship for the next 5 years and needs nothing on the premises, okay, they can identify that they're just going to leave anything and everything that's in there. Okay, all the furnishings, all the personal property, everything. Okay, so that needs to be denoted on the listing agreement. All right, now subsequent agreements mean purchase agreement supersede listing agreement. Okay, but we always need to make sure that the seller is on board with any new terms. So we need to understand what their required and or preferred terms are in the listing agreement. And if they should change, that's fine. Okay, and they'll need to agree to that in writing. But we just need to make sure that we have an understanding of what they want and looking for, and that we can provide for that when signing this listing agreement. Okay. And then the broker authority and compensation. Okay, the authority usually includes putting the property into MLS, being allowed to advertise the property, cooperating with buyers and other agents, and then receiving offers. We don't receive good faith deposits typically. Obviously, that goes through escrow. But in some markets, and back in the old days, that's something they used to do. Compensation has to state clearly the amount or the rate, okay, and when it's going to be paid at close of escrow. Now, we will look at on the actual contract, okay, for residential listings, there needs to be a boldface negotiability clause, Okay, that commission is not fixed by law and is negotiated between seller and broker. Now, this is if you are handwriting or putting this onto paper as a contract. This is probably the one spot that most contracts will fail. Okay, because people aren't putting the negotiability disclosure. They're just saying it's a 2.5% commission or a $25,000 flat fee or whatever it is. Okay, so luckily, when we're using our pre-formatted CAR contracts, that's already in there. All right, one thing we didn't mention is that our CAR contracts, okay, they're already pre-formatted. They've already gone through rounds and rounds and rounds of review and critique. And then finally, legal, okay, to make sure everything in there fills the legal requirements, okay, of an actual contract of the California law, okay, and is going to be, if we fill it out properly, okay, is going to hold up not only for our clients, but for us if we ever need to use that, to ensure payment of commission or the right to sell the property or whatever it might be. Okay, so it's really important that we explain how the compensation works and what our authority is, and that the seller confirms understanding all of that before they actually sign. Okay, and then finally, the exclusive right contracts have to have a termination date. We talked about that a little while ago. Okay, for 1 to 4 units, that can be no more than 24 months from when they sign. Okay, and or 24 months in terms of when it actually starts. So again, technically it doesn't need a start date in order to have a valid contract, but you do have to have a termination date, and it can't be more than 24 months, okay, after the listing starts. So that's pretty much what the requirements are. Again, just like all slide decks, we will put this into the chat, and I'll put the old Word doc that we have as well that's got a little more explanations in writing in terms of all the different requirements. So any questions on any of that before we jump in and actually look at the contract? Okay, take that as a no. And if there are questions at the end, we can always go back to it. So again, we'll put that slide deck and all the information on the legal requirements of a contract into the chat as soon as we're done. So let's move on to the listing agreement. Okay, and you're looking at my page and it says disclosure regarding real estate agency relationship. It doesn't say listing agreement. That is correct. Remember, we talked about these come in a package through zip forms. And the most important document in a real estate transaction is the one we were looking at, the real estate disclosure regarding real estate agency relationship. So this is always going to be first, okay? And this is going to be the first document that is going to be signed, because what this does is it establishes the relationship between client and agent, that they are agreeing to work together. Now, without us agreeing to work together, okay, technically we're not allowed to put any contracts together. So therefore, that has to be signed first, and that's why you will always see that as the first document in any package, whether it's a listing package, purchase package, lease package, lease listing package. Okay, that's always going to be first. So this is actually the first page of the residential listing agreement. You can see right on top, in parentheses, okay, underneath residential listing agreement, it says exclusive authorization and right to sell. Okay, CAR form RLA. All right. Now, we talked about the fact that we don't want our agents, or don't recommend our agents, using an open or a seller reserved form. Okay. And most agents understand and realize that and don't intend to. Okay. But as you're going through these, sometimes you click the wrong button. All right. And the wrong one will pop up. So we just need to make sure when you're actually going through and starting to fill this out, okay, that you do verify that it is the exclusive authorization and right to sell. Okay. Now, right on the top left-hand side is your first. Now, everything that has lines, okay, is going to be fillable. All right. And when we say fillable, it's going to be fillable through the zip forms program. okay, which will allow you then to download, to email, to send via digital signature, okay, to your clients. All right. The one thing that this does not allow you to do, okay, is print a blank copy. All right. Now, there is ways to kind of fool the system into allowing you to print it without actually putting anything in there in terms of information, but it will require periods and commas and spaces, and it is a little difficult to navigate through. Okay. But what you can do, it's not listed on here because I did put an address. If anybody can see my screen or looking at me, I'm holding it up, you can print a sample. Okay, and this will allow you to go through and print it out without any information on it. All right, so if you print the sample one, you can get it to review. All right, I will put this into the slide deck so you can just print this one out without having to go to zip forms and jump through those hoops. People just want to have a quick reference to go back to and not have to, like I said, jump through the hoops of going to zip forms and creating a transaction and printing it out and all those type of things. So I will put this one into the chat as soon as we're done. So up on top left-hand corner, it says date prepared. Okay, this is the contract date. So when you see other documents such as a counteroffer, an addendum, something that refers back to a contract, it's always going to ask the fill in the blank on those ancillary documents is going to say residential listing agreement dated. Okay. And what they're referring to is the date it was prepared. Okay. Not the date that the seller signed it, not the date that the agent signed it, not the date that anything was ratified. Okay. We're just talking about the contract date. So when we talk about the contract date, it is the date prepared. Okay. And for the listing agreement, it's up here in the top left-hand corner. Okay, and that's usually the date that you're actually filling this out. Okay, can you have a contract that's prepared on a different date than signed? Absolutely. Okay, I might be filling this out at 9 p.m. on a Sunday night. Okay, and my clients didn't get it until this morning, so they signed it this morning. Okay, so date prepared was May 31st. Okay, the date it was signed is June 1st. Okay, so time frames may start after things sign. Okay, but when we're referring to the contract date, it's always going to go and default back to the date it was prepared. Okay, so number one, this is an exclusive right to sell. Okay, and then we have a blank line that says seller. Okay, so this is the person that we are working with to sell the property. Now, one thing to note is that in order to have a valid listing agreement, technically you only need one seller on title to sign. Okay, now that can be a little bit confusing. Okay, and it could potentially cause problems down the line if you're only having one person on title sign. Okay, because just because one person signs, okay, doesn't mean that only one person can close. Okay, everybody needs to sign the closing documents in order for it to close. So if you have let's say a husband and wife, and the wife is traveling for business, but the seller, they both decided they need to get this property on the market yesterday. Okay, the seller's the only one who's available, or the husband's the only one who's available to sign. Okay, he can go ahead and sign, and that can start the process because that gives us a valid listing agreement. All right, but we better make full well sure, okay, that we've had a conversation and know that the wife, once she gets back from traveling, okay, is on board, intends to sell, and will sign all the closing documents. Okay, so that's important that we know that up front. Okay, that's why it's really important we do our homework, all right, before going to listing agreement, finding out who's actually on title. All right, so that brings up the other thing is that we may have gotten a call from John Smith to sell the property. We get there, or we do our research, and the property is actually owned by Mary Jones. Okay, so that's going to require some follow-up. Okay, Mr. Smith, we're seeing here that Miss Mary Jones is the owner of record. Okay, how do you relate to that? Okay, oh, that's my mom. You know, she just passed away, and we're selling the property for her. Okay, or that's my mom, and you know, unfortunately, we've had to put her into some type of a retirement community. So that's all well and good. Okay, we just may need some additional documentation in order for that to happen. Okay, and or you know, somebody's trying to sell a property that isn't they have no authority to do so. So it's better for us to find that up first rather than wait until the end. Hong, you had a question. I see your hand.
Yes, Romeo, can you hear me okay?
I can hear you.
Yes. So what happened if the house only have one owner, but now they are married? So California is a community property. So the spouse have to sign it too or no?
Not the actual contracts. The wife may be required to sign what's called an interspousal grant deed, and that'll be up to the title company to determine if that's required. When I say title company, escrow and title, depending on where you're at, to determine if that's actually required. If the property was acquired prior to the marriage and it's held as sole and separate, it may not have to have additional signatures. If it was acquired as sole and separate during the marriage, then typically there was already a document signed previously, in which case another document will need to be signed.
Okay, so it's up to the escrow to
Yes,
see
that's not
that.
for us to determine.
Got it. And then the initial the agreement, just the whoever person have a name on the property can sign. That's still valid. That's good enough.
Correct.
Got it. Thank you. Thank you.
You're welcome. And I see is there another hand up?
Romeo, I have a question.
Sure.
This is Iris. So let's say two sellers, and like the scenario that you just brought up, one seller is available, the other seller is traveling. So if I say, okay, then let's say your wife can sign we can also add your signature on the listing agreement. And by then, what form do I use? Do I use modification?
So you could use a modification. You can just have them sign this document, or you can use the additional signature addendum. There's a number of different documents that would actually allow you to do that. It wouldn't be necessary because as long as both parties are on board, it's perfectly fine as long as they all sign the closing documents.
Okay, thank you.
You're welcome. So now we've established a seller. So the seller is going to hereby employ and grant the broker. So that's Century 21 Masters. So we do see agents get confused and they'll put their names in there. Okay. Technically, all contracts need to be with the broker. Okay. So that would be Century 21 Masters in this case. All right. And they give the exclusive and irrevocable right to sell or exchange the real property described as. Okay. And this is, again, for residential properties, this is typically where we are putting the address. Okay. 2633 Ocean Avenue. That's our office here in San Francisco, situated in the city of San Francisco. Okay. In the county of, all right, San Francisco is its own county. But if this was a Daly City, it would be the county of San Mateo. And then the zip code. Okay. Or we can put in the assessor's parcel number. Okay. Again, that is a better way of identifying a property more so than the address. Okay. Or we can actually put in a legal description and attach that if we have it. Okay. And we can say see attached. All right. So that establishes who the parties are, okay, and what the property is. So now we move down to 2, and that's the terms of the listing agreement. All right. So we've got basically 2 things here. Okay. The first is the listing period. So as we mentioned, technically we don't have to have a beginning date. All right. But most people are going to put in a start date, which will be today's date. Okay. Or tomorrow if everybody agreed that, we're going to start this tomorrow. All right. So that would be our start date. And then it ends at 11:59 p.m. That's our termination date. So remember, to have a valid contract, okay, 2A1 needs to at least have a date in the ending period. Okay, remember we talked about it's not to exceed 24 months if it's 1 to 4 units. Okay, there are some exceptions to that, but we don't need to worry about that. For the most part, across the board, it's going to be 24 months as a maximum. Okay, now probably the biggest mistake that we see on listing agreements that would invalidate them, okay, is 2A2, and that's listing price. Okay, and a lot of times the reason for that is we go out and we get a listing and we realize, you know what, it needs paint, it needs landscaping, there's still some work that has to be done. The seller wants to get the process started, but the kids are still in school and we're not going to go on the market until mid-June. Okay, so a lot of times we're signing these listing agreements a lot earlier, okay, than the property is going to go on the market. Okay, and a lot of times that's our doing, in that we're trying to strike while the iron's hot. We don't want to wait, let the seller think about it. We don't want them to bump into somebody that they know or somebody else knows it's a realtor. We want to get this thing signed ASAP. Okay, and a lot of times what agents discuss with their clients, okay, their sellers, is that we're in real competitive markets. Okay, we're in hot markets, and just because we would price this at $1 million today, okay, next month when everything's done, it's going on the market, it may be, you know, at $1.1 million by that point. Okay, or God forbid things are going in the other direction, and it might be at 900,000. Okay, so a lot of times agents will either leave the listing price section blank, or they'll put in something like to be determined. Okay, or actual list price to be discussed prior to going into MLS or something of that sort. Okay, we'll see notes in there as opposed to prices. Okay, without a price, we don't have a valid listing agreement. Okay, so even if you have to put in a placeholder, okay, $10 million, $1, whatever it is, okay, and then note that that's just a placeholder somewhere else, okay, that is fine, but you have to have an actual price in there. Okay, go ahead, Om.
Hi, Romeo. Yes. So back to A1, beginning date and end date. So let's say if I was to give this this form to a prospect, so we set it out starting at June 1 for the contract, and then we didn't meet until, let's say, tomorrow. Do I need to reprint that and update it to?
No, not at all.
Okay. So I still can keep it as a June 1 to expire, let's say 6 months from now.
Yes.
And then he can still sign it at June 2nd.
Yes.
Oh, so I don't need to read. Okay, so the date doesn't need to be updated.
No. So again, you don't actually have to have a beginning date. So therefore, it doesn't matter. As long as it's not 24 months after, then you're perfectly fine.
Okay, so I can still keep that form. Okay, thank you.
Good morning, Romeo. Regarding the list price, if we put the list price there and the market changes and we need to increase it or decrease it, whatever, do we need an addendum?
Modification to terms.
Okay, thank you.
So going down, and this is what we talked about when writing contracts by hand or putting something together that is not a standardized CAR form. This is one of the big issues that will invalidate a contract, and that's item number C. It's in blue, okay, compensation. Notice the amount or rate of real estate commission is not fixed by law. They are set by each broker individually and may be negotiable between seller and broker. Okay, that has to be part of the contract. Okay, luckily, when we're using these standardized forms, it's automatically built in there. Okay, so this next section deals with compensation. Okay, so 4B or C1, excuse me, is compensation to seller broker and only the seller's broker. Okay, so this allows us to put in either a percentage, okay, and or a flat dollar amount. Okay, it also allows us, if we check the box, to create a compensation schedule. Okay, and a compensation schedule would be something of the sort of, if the property sells for $1 million, compensation will be 2%. If it sells between $1 million and $1.5 million, it'll be 2.5%. If the property sells for over $1.5 million, compensation shall be 3%. Okay, so it's detailing an actual schedule dependent on how the property sells. All right, now right underneath this, and this is where agents get a little bit confused. Okay, item C2. Okay, additional compensation to seller's broker if buyer is unrepresented. Okay, this is not meaning that you are representing the buyer who wants to buy this property. Okay, and you have a buyer representation agreement with them and you're acting as their full agent. This is a small faction of buyers, okay? And we've had these new commission laws for almost 2 years now, and I've seen probably 5 unrepresented buyers, and we're doing thousands of transactions. Okay, now there's probably more that I just haven't seen, okay, but that I know of, okay, in the last 2 years, there's probably been about 5 unrepresented buyers. So this is not something that happens very often, okay? But every once in a while, a buyer thinks that this is the best way for them to either get the property or the best way for them to get the best deal, whatever it might be, okay? Now, in order to facilitate a sale for your seller, okay, you can't exclude, you have a fiduciary duty to your seller to get this property sold, okay, for the highest and best price, okay? And if a buyer comes through that doesn't have representation and or doesn't want representation, okay, it still may be in the best interest of your seller to help those people, okay? In which case, you may have to furnish them with contracts, disclosures, all of those type of things, and do all the paperwork. Okay. In doing so, even though the buyer is going to sign off on you taking any liability for or to them, okay, there's still additional work to be done. Okay. So we're telling Mr. Seller, well, you know what, Mr. Seller, if somebody comes through and we have to help them, okay, we're going to need to get compensated for that. All right. So we're going to add, let's just say we've got 3% compensation on the selling broker side. Okay. If the buyer is unrepresented, okay, most buyers who are represented are going to ask for 2.5% or 3% commission. Okay, if this buyer comes through and is unrepresented, you know what? We're going to do it for only another 1.5%. Okay. Now, some people choose not to check that box, in which case, if there's an unrepresented buyer, you may not get any additional compensation. Okay, so don't wait until that scenario comes to you. Again, it doesn't happen very often, okay? But when it does happen, we've seen agents who have gotten no additional compensation having to help this unrepresented buyer, okay? Because it is in the best interest of their seller. Now, the next section, C3, this is another one that people get very confused on. And this is the continuation period, all right? Now, a continuation period, okay, is the time frame after a listing is expired or canceled, okay? And what that means is that if a listing is expired or canceled, okay, if during the continuation period, anybody comes, okay, that previously showed interest, wrote an offer, was showed the property during your listing period, okay, you may have the right to still represent the seller and get a commission if it sells. Now, most agents gloss right over this. And if this happens, let's say you've got a listing that expires on June 2nd, okay? You bring a buyer to go see it today. And as you're leaving, the seller pulls the buyer aside and says, you know what? My listing expires tomorrow, okay? After tomorrow, I'm not going to have to pay a 3% commission. Why don't you come back and see me on Wednesday and we'll put a deal together? Okay. If you have a continuation period, this would prevent the seller from being able to do that. Not that the seller would. Okay. But every once in a while, you have a listing that expires that for whatever reason, just you couldn't put a deal together on. Okay. And once that happens, you furnish the seller the list of everybody who put offers, who came through to see it, who showed interest in it. Okay. And if for 30, 60, 90 days, whatever your continuation period is, if that person comes back and wants to buy it, okay, you are entitled to a commission. So again, it's a way to protect ourselves, okay, from jumping through all the hoops, doing all the legwork during the listing period, only to have it not sell and then find out that it sold to somebody who came through during our listing period, okay, and we didn't get paid for it. So that's a continuation period. We recommend 90 days. And what that does is, again, discourages sellers from trying to let our listing agreement lapse or cancel it and then sell it to somebody else, okay? Or sell it to somebody that came through during our period.
Romeo,
Yes.
Maybe I'm missing something obvious here. How would we know if a buyer comes back and wants to purchase the property?
Well, sometimes we don't. But what would happen is everything is public record. So if the property, let's say, expires today, and in 30 days we see that it's sold. Okay, well, if we see in 30 days it's sold, we go to the tax record and find out, you know what, Joe Smith bought it, and they actually submitted an offer when we listed it. Well, we're entitled to a commission on that.
Great,
So,
thank you.
yeah. So, and what part of the continuation process, in order to make it enforceable, is we have to, at the end of a listing period, we have to send the seller a detailed list of all the people that came through, made offers, showed, saw the property during our listing period. Okay, and those are the people that are covered under the continuation.
So obviously we have to address this section to the seller when we are doing the listing presentation, right? So the seller knows exactly. Thank you.
So Romeo, so does this a list of people that see the property, or you have to be put in an offer?
No, it could be a list of people who saw the property. Okay, if we have that
Okay.
list. Now, it can't be just blanket agents saying, you know, and you list a list of all the agents. It actually has to be individuals. So people who came through and signed your open house, people who, you know, you identified through other agents who showed it, people who requested disclosures on Disclosures.io, you know, people who actually wrote offers. Okay, so it can't be just a blanket statement of, you know, all the agents at XYZ Realty and their clients.
So-
It actually has to be the clients themselves.
Okay, so the client come in and sign the open house signing sheet. Will that work or no?
Yes.
Okay, great. Thank you.
So now with that continuation right, okay, is underneath that the seller obligation to pay previous brokers. So you may be getting a listing that was previously listed, that was canceled or expired. Okay, so you need to find out from your seller, okay, is there any other clients, okay, and or brokers who may be entitled to get paid, okay, if this property sells, okay? And we do this to protect our sellers in that they may owe 2 commissions, okay? So the last thing we want to have happen is an offer comes in, we get it ratified, we get it sold, only to have another brokerage come back and say, hey, we're owed a commission. And the seller looking at us like, well, shit, I owe them a commission, so I don't want to pay your commission. Okay, we don't want to be put in that position. All right, and then the new law that just came in January, okay, C5, brokers paying a referral fee related to the representation of a seller. Okay, if there is going to be a referral fee, it needs to be disclosed, okay, as soon as we possibly can to a seller. So if we got this as a referral fee or a referral from, you know, brokerage X out in New York, we need to detail, okay, when we're signing this listing agreement that we are going to be paying a referral fee to that broker. Okay, we don't need to identify the agent. So that's something that's important. You know, some sellers may not like certain agents and never want to see their name anywhere. Okay, and we don't detail who the agent is on referrals. Referrals are broker to broker only. Okay, but that does need to be done upfront and as soon as we possibly can, which would be as soon as possible. Disclosure point for a seller would be on the listing agreement. Okay, and then rounding out page 1, we talked about items excluded or included. Okay, if the seller wants to include anything that's physically attached to the property, which is assumed is going to be taken with, or if they want to exclude, meaning they want to leave the car that's in the garage, okay, or the shed and all the tools that are in the backyard, okay, this is where they would put that. So we only got about 10 minutes left, so I just want to fast forward a little bit. We're not going to go line by line on these things. If you do go to car.org, you can actually see a full listing agreement presentation, and they do go line by line. So, and that is on YouTube as well. You can find it. But usually that's going to take probably 2-3 hours to go through something line by line. So we're just trying to focus on some of the most important topics that come up and the ones that are going to keep you the most protected in terms of where you're filling in the blanks. Okay. Now, one thing to note on page 2, buyer supplemental offer letters. Okay. By default, and this was real popular 5, 10, 15 years ago when we had real competitive markets. Buyers would submit with their offer, okay, all this information about themselves, okay, who they are, where they work, where they're from, who their kids are, what their dog's name is, all these different things to the sellers. Well, unfortunately, a lot of the things that were contained in those letters, okay, could be construed, if the seller liked or didn't like some of those things, it could be construed as discrimination, okay, or violating fair housing laws on the seller's part. So what the contract does now is it automatically excludes, okay, any letters from coming from buyers, meaning that if you get an offer package and it's got a letter in it, we can exclude that. Okay, it's telling, and buyers and buyers agents already know that. Okay, but that doesn't mean that they won't automatically send it sometimes. Okay, however, the seller can say, you know what, this property has been in my family for 150 years. I would like to know a little bit about the people who are making offers. Okay, so we need to make sure that we stress to them that there are complications that can come from that. However, if they are confident that they can review those letters and not violate any fair housing laws, then they are allowed to check the box here and says the seller instructs broker to present those. Okay. Moving down on page 2, compensation terms. Okay. This is compensation earned and seller shall pay broker as follows: a completed transaction or seller default. Okay, that's important to note, in that sellers sometimes think, well, the only time I'm going to pay a commission is if I close escrow. So they think they hold all the cards. Okay, to a certain extent they do. However, if they default somehow by preventing us from marketing the property, from not entertaining offers that are coming in under the terms of this contract, okay, by dragging their heels so our term expires, okay, that would be a seller default, and we may be entitled to commission. Let's see, moving on to
bought it locally, but you know, I want to tell you.
Oh, you started off and then I think you're muted, Neil. Neil, you still there?
I think he muted himself. He opened the mic by mistake.
I made, thank you, Iris. I did. I made a mistake, and I apologize.
Yeah, no worries. I thought you were going to add something to that. That's okay.
No, you're doing a great job. Keep it up.
Thank you. Just got a few minutes left and only a few more things to talk about. So as we mentioned, by default, we have a listing package. We also have a purchase contract package. We also have a lease listing package, a leasing contract package. Okay, and all of those are going to contain ancillary documents. So automatically, number 9 of the contract says that the seller acknowledges receipt of the disclosure regarding real estate agency relationship. Okay, so that's already pre-checked. That's already in there. Again, as long as the client is signing this full package, we've fulfilled our duties in terms of the agency relationship. Okay, and it's automatically built into the contract. So moving on to page 5.
I will say, apologize, Romeo. I will say that we just got a memo from Jan today that all of those documents need to be uploaded into SkySlope. So not just the deposit receipt, but lease documents, et cetera, et cetera.
Yes, absolutely. Thank you for that. I don't
Okay.
think I've had a chance to see her
No,
email
it
yet, but I will
just
definitely
came
review
through.
it.
Yeah, it just came through this morning.
Got it. So new for December of 2025, okay, and we talked about this with the new laws, okay, and it's automatically built into the listing agreement now. That protects us from sellers saying they don't, they want us to spruce up their house and make it look as great as possible, and don't want us to share or show what the property really looks like. Okay, so this contract protects us from doing so. If you remember when we talked about the new laws, anytime you digitally alter a picture, okay, we now have to disclose that the picture has been digitally altered, and we have to give access to the original picture. Okay, so two things under that new law. A lot of times, if a property is, let's say, a fixer, okay, we can add digital staging. We can add new floors. We can make the walls look like they're painted, okay, and make this property look like $1 million, okay? And that seller loves the fact that we can do that, okay? But the seller may not want us to show what it really looks like. Well, unfortunately, we can't do that, okay? And that's built right into the contract to protect us from a seller saying they don't want or we can't show any original pictures, okay? So it's built right in. Now, one thing we need to note is that this contract, when we get down to page 6, okay, you'll see here item 17, management approval. If an associate licensee in a broker's office, meaning a salesperson or broker associate, enters into this agreement on broker's behalf, okay, and all of these contracts are on the broker's behalf, all right, the broker or manager has the right to cancel this agreement in writing within 5 days after its execution. Now, this is built in as a protection, okay, just in case we fill something out wrong. Okay, a lot of times the biggest thing we see is an agent back when, let's just say, you were negotiating commission for both sides, meaning for buyer and seller, and it's a 5% commission. Okay, well, some people associate 5% as 0.05. Okay, and they would put in the contract 0.05 when the contract actually states 0.05%. Okay, so that is something that we as management would have the ability to go back and say, I'm sorry, Mr. Seller, that was a mistake. We're not selling your property for 0.05%. Okay, and sharing 2.5% with the other side. Okay, so it's important. So how do you get management approval? You put in SkySlope. Okay, as soon as you put this in SkySlope, okay, that will trigger our compliance team to go through and make sure that everything is done in the proper way. Okay, if you don't put this into SkySlope within 5 days, okay, any mistakes, okay, can be your fault and your issue. In which case, you put in 0.05%, you may owe the company, okay, whatever the company split is on 5%. Or on 2.5%, or whatever the minimum is. I guess the minimum is 2%. Okay, you may only be getting paid based on 0.05%, but the company, okay, out of your pocket is getting, let's say 20% because you're on 80-20, 20% of 2%. So you're writing a check. Okay, so imperative that as soon as you get documents signed, you get a SkySlope file open. Now, much like on a purchase contract, like we talked about, a few weeks ago, we were talking about mediation and arbitration. Mediation is built into the listing agreement. Okay, arbitration isn't. Okay, just like it's agreed to in the actual purchase contract. Okay, in the listing contract. Okay, if the seller and the broker desire to resolve disputes arising through arbitration rather than the court, they can document their agreement by attaching or signing an arbitration agreement. Okay, so that would be separate, okay, if you want to do that up front. Okay, you don't necessarily have to, and most people don't. Okay, I'm not saying that's right or wrong. That's just not something people are doing up front. Okay, and then finally, we got about a minute left here, and we're just going to go to the signature page. Okay, we have built into the listing agreement, okay, a representative capacity disclosure. Okay, so you don't actually need an additional form. Okay, we can check the box for entity sellers. We can put in what the entity is and who the legal authorized signer for that entity is, whether it's a trust, a probate, power of attorney, LLC, something of that sort. Okay, and then the seller signs and the broker signs. Now we say the broker signs, that is the agent who's signing on behalf of the broker. Okay, and that takes us right to 11 o'clock, right to our signature page. So hopefully that gives everybody a good idea of the residential listing agreement. It is fill in the blanks. You do have protections because of our management approval. So don't be afraid of it. It's definitely something you want to make sure that you are very familiar with before going out on a listing appointment, so you can actually explain it well and be able to answer any questions that the seller may have, going through it. So this is definitely one to role play, signing the listing agreement in addition to your listing presentation. Okay, don't leave that for the first time you're actually going to get one signed, is the first time you're looking at it, okay, in detail. So I'm just going to stop my share, and then I'm going to